Delhi High Court. He's a senior counsel, Lordship. He would be coming to address my Lord. Lordship, I was humbly praying because 59 in the usual course, it may not come up today. I was humbly praying if it can be taken up at 2 because it will take only 5 minutes. It's a criminal revision. There are similar proceedings where proceedings have been quashed. This is one of the rest of the petitioner. Only one person was left. The other two has been quashed by this Honorable High Court. I have also annexed that to my petition. Only at 2, it will not take.
I have
Lordship, I've
one
seen that.
year matter.
I've seen that, Lordship. It will not take more than 5 minutes. Lordship, you can take it from me. This is at the stage of motion, and there is a coordinate bench which quashes two proceedings on the same matter. This is the rest of the petitioner. This is the only sole petitioner who was not arraigned as a party in the other two quashing petitions. Because warrant of arrest has been issued. That is the only urgency, madam. He will come and argue not more than 5 minutes, Lordship, by the clock. By the clock, I'll
Come. Yes.
59, item number.
Yes, call the list. 2 p.m. Yes.
59, 2 p.m.
No, if not reached.
Order number 1.
My lord, I am for the petitioner, my lord. My lord, I have already served upon the other side, your lord. My lord, this is, my lord, initially.
Where is your affidavit of service? Affidavit of service?
Already served, my lord.
What is the application?
My lord, initially, my lord, a writ petition was moved in 2019, my lord, for settlement of an insurance claim, my lord.
Affidavit of service. Or recalling?
No, my lord, this is for clarification and modification. This is for clarification and modification of an order passed on 5th of February 2019, my lord. My lord, initially a writ petition moved, my lord, for settlement of an insurance claim. On 5th.
Which court passed the order?
My lord, Honorable Justice Boshak, my lord, he was pleased to pass this order, my lord, on 5th of February. Both the orders has been annexed here, my lord. My lord, on the 10th of June, my lord, another order was passed.
So his lordship is available.
My lord, we have filed this application for modification of this order, my lord, for clarification of this order. Because he was clarifications, my lord.
You look the list. This determination is not with this court. Okay, you look the monthly list. That determination is not with this bench. Okay. Okay. Modification of that order, modification is to go to that bench which been passed the order. Okay, and his lordship is available. Justice Boshak is
Jurisdiction.
No.
For the modification.
No. Hey,
Only for settlement of an insurance claim, my lord, which we have
not
from the IRDA, my lord.
Merit, I cannot.
Modification is only, my lord, he was seeking a clarification
You read.
on the powers of the IRDA, my lord. And the textbook was not available with us, my lord, so we could not satisfy his lordship. So that is the only modification, my lord, clarification he was seeking, my lord. Otherwise, your lordship has the jurisdiction, my lord. This is for settlement of an insurance claim.
It's a part 2, part 1. Part 1 কোথায় গেল? Part 1 কোথায় গেল? Part 1 টা দিন। আচ্ছা লিখুন the matter stand release. শোনো, stand release due to want of my determination.
application for,
Don't know. You don't know.
my lord, I'm instructed from his kindly.
After vacation, after vacation.
Okay. Great.
After vacation, নিন তাড়াতাড়ি নিন। No, item number 3.
Order number 3, my lord, I beg to appear. for
আগে
I beg to appear for the respondent number 4, my.
হ্যাঁ হ্যাঁ
I beg to appear for the respondent number 4, led by Lani Honorable Uday Narayan Betar.
I am for the,
application for interim order.
yes, my lord.
এটা order pass হচ্ছে না।
Which interim order?
My lord, a
Stay of
copy has to be
operation of
served
the
upon me, my lord.
letter of the Director of Mass Education Extension, West Bengal such and such, as well as the communication of the district mass.
My lord, the, may I, my lord, the short facts is involved, my lord, may I tell you? Petitioners are the non-teaching staff, my lord, the Ramkrishna Mission, Blinds Boys Academy, Narendra. They are under the control of the Mass Education Department. My lord, the, you will see page 14 on the application for interim order. They were appointed in the year 2006. Lord, this is the approval memo with the pay scale 36007050. You will see page 14. Just, my lord, the short facts, my lord, I tell you. Page 14. This is the first petitioner's approval, right hand side, scale of pay 36007050. You also got it, my lord, the page 14 of my application for interim order. Vasudev Pan.
Huh? Oh. Hey, 1 minute, 1 minute. Yes, Mr. Dotto, item number 2. Item number 2, one learned advocate paid for accommodation on behalf of Mr. Banerjee. I ask the matter will appear after vacation. Any order needs to be passed. Any order needs to be passed. Eh? Any order needs to be passed.
My lord, this is the
So you want
I just, my lord, I tell
you want to restrain the respondent from
I tell you.
recovering the overdone amount.
This fixation, even, my lord, the advertisement also, this scale was prescribed that in the post, this scale was prescribed. 2006, I was appointed. All on a sudden, 2022, they said, no, your pay fixation was wrongly fixed from 2006, my lord, that will be reduced in the lower grade pay scales. My lord, that has been challenged before the Honorable Court. Affidavit has been exchanged. Matter was running in the list, my lord, the last occasion, my lord, this was running in the list before Justice, the Honorable Justice Om Narayan Rai. Matter was hard. Affidavit has been exchanged. Now, all on a sudden, they said, there is no stay order, refund the entire amount. Calculating from the date. My lord, the decisions, my lord, reducing my pay scale, that is sub judice. That's all, my lord, whether I am entitled or not. Well, at this stage, my lord, if they recovered the entire amount of the petitioners, my lord, I will not get salary last 2-3 years. 2006 onwards, my lord, the Rafiq Mosi judgment, my lord, I have.
Have you retired?
Not retired. Rafiq Mosi judgment also. Rafiq Mosi also is in service. My lord, the non-teaching staff, respondent cannot recover any amount due to wrong fixation of pay scale. That is why, my lord, I filed an application. Now, 2025, July 2025, you will see page 30, they, my lord, issued a letter, my lord, instructing, my lord, the concerned authority to recover the amount, overdone amount, calculate the amount and recover from the salary. This is, my lord, entirely harsh, my lord, at this stage, matter is in the court.
My lord, the disbursing authorities, my lord, the principal secretary, mass education and
Yeah, my
extension
lord,
director.
senior friends, my lord,
But I am the, my lord, respondent number 4. My lord, till now, my lord,
He is my
canon
employer.
application has not
Huh?
been served upon us.
He is our employer, but he is probably he is.
Mass Education Department.
No, he is my lord Ramkrishna Mission blind boy.
Order number 4,
My
my lord.
learned senior
Lord-
friends is appearing for the master.
Yes.
Order maybe for serving of the can 1, my lord. Till now, the can 1 has not been served.
You have not served.
Can
No,
have,
no, my lord.
এই তো can sir, এই তো,
কাছে দিয়েছে।
direct তোমার secretary receive করেছে. This is the seal. You will also kindly see evidence.
Hand over fine.
Where is the memo dated 5th January 2022?
5th January 2022, page 19 of my application.
Page 19.
19. This is the, my lord, the impugn order in the writ petition. State in the.
Yes,
Page 31, you will also page 31.
he is claiming that you have not served the application.
I have served.
Copy of the application.
I have,
Copy of
sir.
the application has been served upon the office. They have not received yet. That is
Yes,
the
ma'am.
problem.
Copy of
There is
the. No, I have no allegation against the Ramkrishna Mission blind boys. He is supporting, probably supporting me. Well, I am employer. My lord, my learned senior friend is appearing for the state respondent. Page 31. At this stage, my lord, my lord, at least, my lord, the status quo to be maintained. Otherwise, entire amount, page 31, recently, 17 July, issued this letter addressed to the Ramkrishna Mission to recover the amount, overdone amount.
Well, let me take instruction. Let it appear on Monday. Let
His
Monday or
copy has
Tuesday.
been served, my lord, 1 month ago.
Awesome. Awesome.
এই তো দিয়েছি বলো।
This application has been can dispose of.
Item number 4.
Petitioner, yes. Until the disposal of the okay, after vacation.
One formal order,
Eh?
one formal order we recorded.
One application. Legally, hard landed advocate appearing for the respective party leaves the matter for further consideration.
I'm only for respondent number 2.
আচ্ছা ইয়ে আপনি ওই যা ইয়ে 1 week after the ensuing puja vacation or 2 weeks after the ensuing puja vacation. Next.
Item number 5.
Should I appear for the petitioner?
My lord, I appear for Union of India.
Where is your beef?
My lord is coming, my lord.
Oh,
I would like to file my opposition.
huh?
Opposition is ready. Let the brief come. I will file my opposition.
But my lord, my learned friend's client should not take, my lord, any adverse step. I'll tell you, lordship, what. My lord, there are, my lord, two types of, my lord, the writ petitioner is the West Bengal State Electricity Distribution Company Limited. Now, my lord, they procure electricity and distribute amongst the consumers. Now, my lord, electricity, my lord, are of two types, renewable and non-renewable. Now, my lord, today, my lord, we are concerned about renewable energy. Now, what is renewable energy, my lord? Renewable energy, my lord, comes from solar, then, my lord, hydel, then, my lord, as they call, my lord,
solar then
my lord, solar, wind,
wind, yes.
biogas, and hydel.
Okay.
Now, my lord, the central government, my lord, has come up with a policy that the distribution companies, they call it in short DISCOM, they have to, my lord, procure this renewable energy, my lord, for a particular proportion every year. My lord, targets have been fixed from 24-25 to 29-30.
24, 25 to 29, 30.
30. And my lord, if this is not achieved,
30 it is
yeah, 29-30 for 5 years.
Oh, yeah.
But I'm cutting a sorry figure before the learned advocate general Miller. This is I'll do it. Let me take instruction. Miller, for some accommodation, Miller, because
But I don't mind for the accommodation. Only thing is, my lord, let them not impose any penalty on me. And lordship hears it out, my lord, after the vacation. I need not.
Miller, in that case, Miller, if that Miller, my undertaking cannot be recorded because I have to take instructions, Miller. But if not, because this Miller, this writ petition was filed in 2024, I suppose.
Yes, yes.
1 year back, and it is once it appeared, Miller, before
The
this.
one application has been filed.
Yes. Now, my lord, the purpose for which, my lord, this application has been filed, if your lordship may kindly take, my lord, annexure P2 of the application at page 17.
From seeking injunction, restraining the respondent from seeking compliance report in respect of renewable consumption obligation from the petitioner on the basis of the notification dated such and such.
Yes. That your lordship would find at
Impugning
page 17.
impugning the present writ petition pending disposal of the present writ petition.
Well, we have we are not having a copy of that application. If my learned senior friends কোথায় serve করেছে আমাকে দেখ
তোকে তো দেওয়া হবে না, তোকে তো চিনি না আমরা। কি? আমি অ্যাপিয়ার করেছি, তোকে দেবো কেন?
একবার just take the
Done. Yes. Taking time to take instruction.
Well, keep it, sometimes next week, my lord. Or else, if my learned friend can assure that no penalty will be
My lord,
imposed in
can
the meantime, I can
my
contact after the
learned senior friend understands it better than me. I representing Union of India, Millard, and then I am not representing the respondent number 2.
West Bengal
But
Regulatory
I'm
Commission.
not representing them. Now, my lord, as far as Union of India is concerned, I may take instruction. But, my lord, as far as West Bengal Electricity Regulatory Commission is concerned, my lord, I cannot vouch for their.
No. My principal grievance today is against my learned friend's client.
So, my lord,
Central government.
if that is the situation, my lord, will kindly give. Let me take instructions and come back because I don't want to record an undertaking.
Monday or Tuesday, my lord, whichever day.
Tuesday.
Tuesday. My lord will kindly keep it.
মঙ্গলবার কর।
এখন দাদা বলছিল।
আচ্ছা আসুন।
মঙ্গলবার Tuesday, sir.
আচ্ছা আমি
জ্ঞান তো আপনার উপর service है।
the learned advocate appearing for the applicant. আচ্ছা Mr. Trivedi, learned senior advocate and deputy solicitor general, case for a short accommodation to avail necessary instruction. Stop. In view thereof, leaves the matter for further consideration on
The affidavit of service may be kept. on.
affidavit service.
Oh,
as-
I'm sorry. No. I'm so sorry. No, তাহলে এখন
authenticated. But respondent number 2, you make an effort to serve. Yes.
I'm good.
I don't know, takes.
With my lord.
Review application.
This is a review application, my lord, led by Mr. Vishnu Bhattacharya. My lord, here, my lord, lordship has granted regularization of the petitioner's service. My lord, certain documents were not brought before your lordship, my lord. We have annexed those documents in the review application.
Medical corporation.
My lord.
That matter.
Right.
At the matter, several dates, opportunity of several was granted. They filed a report, your lordship consider aspect of the matter. Full-fledged hearing was there to show thereafter delivered the judgment. My humble submission will be before your lordship, the review doesn't lie. Let them file an appeal or whatever may be, but if they have been advised. But at this juncture, the review application is not maintained.
Madam.
First, my lord, I shall be taking one point. In addition to that.
No, what is your ground?
No matter before
You are saying some documents has not been produced, whether
Yes, it's-
when the matter was argued on behalf of the respondent
May I say this?
or review applicant, whether this document was not available with it at that time.
At 2014 document they are relying.
No, these are old documents. Madam, I'm led by Mr. Mr. Bhattacharya is leading me. Madam, he has a matter before your lordship at 2 p.m. Madam, can this matter be also taken up at 2 p.m., my lord?
2 p.m. how-
He is on his legs. He is on his legs, my lord.
2 p.m. it is impossible.
After vacation, come after vacation.
Then madam, kindly fix the matter at any day after
Only
vacation.
problem, my lord, we are facing due to dependency of the review applications. The order is not being complied. So very vital. Your lord, keep it Monday, no problem. If my learned friend has got any difficulty today.
After vacation, it would take time. to
Only one, your lordship see that Supreme Court judgment, changing of a lawyer in the review petition itself is not maintained. I have got that judgment.
But we have not taken that ground, my lord, that these,
What?
it's lawyer may have changed, but that is not the ground.
In a review petition, you cannot.
Actually, application is taken on Friday. Next Friday, I don't know what will happen.
Next Friday.
Or whether you will be able to
No,
move this
next
matter or not.
Friday certainly will not be. But
Yes. So I am keeping reopening on 7th. And if I don't keep on other day, then other advocate will say, no, today is the date for taking such and such matter. Why application?
And 7th at 2 p.m. madam, kindly keeps it, my lord. Then the matter can be
7, 2 p.m.
Fine, at 2 p.m., 3 p.m. করে fine. That's all.
Hello.
Well, is it at all, Ballard, this side any day subject to lordship other than Friday?
Any day only, other than Friday.
Only Ballard, the review applications, I
have understood. I have understood.
The hearing is required.
I also put the question whether that document was not available to you.
2014.
Available to you at the time of argument.
That document will not improve the case. Your Lordship's very recent judgment of Jago has been relied upon to show, my lord, the document that document said the contractual employee has no right to be absorbed. Well, that has been considered by your Lordships. They have taken Mr. Chaudhary was constantly submitted before this court the contractual documents, and certain portions have been absorbed by the Medical Corporation of India resolvent decisions. Yes, we are regularizing this, and this unfortunately, your Lordship recorded everything.
Yes, I can recall now. Yes.
Your Lordship kindly.
So,
2-3
I am
minutes.
keeping it on 7th. Keeping it on 7th. Heard the learned advocate appealing for the respective party leads the matter for further consideration.
দরজাটা আমার বন্ধ করে দাও।
Yes.
Affidavit service may be kept on.
Every service filed on behalf of the applicant is be kept with the record. Eta agger affidavit of service. Next.
My lord, I am appearing on behalf of estate in item number 7, my lord.
Yes. What happened?
My lord, I am for the estate, my lord. Petition. The grievances
My
of
lord,
the
I am for the
petition.
state. I'm led by Mr. Vikeshai.
I am for the state, my lord. I am led by Vivan Kosai.
Lord, this is an application for setting aside of the resolution dated 20th May 20.
Asansol District Hospital?
My lord.
My lord.
You are appearing?
My lord, I am appearing.
Yes.
My lord, I am coming to the resolution, my lord. Your lordship has already heard this matter.
No, yeah. You give reminder why immediate intervention of this court is
My
required.
lord, because the tender was cancelled by the resolution dated 20th May, my lord. That is at page 43, annexed P4 of the writ petition.
20th
May.
On 3rd June, the matter was taken up for hearing. At that time, you did not.
Yes, I have urged.
Mention this matter. You did not.
I have already.
Bring this fact to the notice of the court.
Yes, my lord, I have brought it, my lord. Then your lordship has asked me, my lord, to serve the notice upon the.
On 3rd June, this matter was taken up for hearing.
Yes, my lord. My lord was.
You appeared on that day.
Yes.
Okay. Now you are filing an application claiming that on 29th May one notice was given.
No, that is the part of the.
So on 3rd June, it was within your knowledge.
My lord, it was.
So why you have not brought on record on that day?
My lord, that is within the part of the my lord writ petition. And my lord, I was directed that Asansol.
In the main writ petition, what you have challenged?
My lord, that is the resolution, my lord. That page 43.
As to why resolution dated under the status should not be terminated. Why they resolved?
My lord,
What was the resolution?
My lord, I am coming to this. My lord, tender committee, my lord, that is at page 43.
You participated in the tender process.
I have participated.
Asansol Durgapur Hospital floated a tender.
Yes.
For what purpose?
For running a canteen.
Running a canteen.
Yes.
Okay.
And
now
I have become, in the technical and financial bid, I have become the L1 candidate.
Technical, 2 bids.
2 bids.
2 bids a tender or technical and financial.
Yes.
Okay. You L1.
I was succeeded in L1.
L1 bidder.
Thereafter.
Now what happened?
Thereafter, tender committee has taken this resolution.
Yes.
And my lord, the observation is this. I am coming to the observation.
They cancel the tender process.
Yes, they cancel the tender process.
Okay, cancel the tender process. Okay, you have challenged such cancellation.
Yes, as because my lord,
by preparing the writ petition.
Yes.
Then what happened?
My lord, that writ petition was heard before your lordship on 3rd June, and your lordship directed me to serve the call upon the that is hospital. I have served this is the affidavit of service, my lord. Pursuant to your lordship's direction, I have served.
Okay.
And my lord, now, my lord, I have taken an application because, my lord, after cancellation, they have not taken any new tender proceedings. But I was an L1 candidate, and, my lord, the earlier bidder, that is, my lord, the successful bidder who was running the tender is still running, my lord. My rates are lower than the, my lord, the present contractor who is working there. And, my lord, I have a credible credential, my lord. And my lord, my tender was rejected on the ground that in the, my lord,
That would be when the writ petition will be finally will be taken for final hearing. Then whether their cancellation of that tender process is bad or not, that would be properly decided. That would be decided. But what in the meantime happened, what has happened that you are seeking immediate intervention of the court?
because this is at motion stage, my lord. I have prayed an ad interim stay of the particular resolution because the resolution is ex facie illegal. My lord, why it is illegal? The FASI, that is, my lord, the FASI license was issued 3 years.
What
But there is a dispute that is what in the trade.
what was their resolution?
My lord,
One line, one sentence.
in the trade license, the name of the secretary was something else, and in the FASI license, the name of the secretary is something else. FASI license was issued 3 years earlier or 5 years earlier. It was validity period of the FASI license is 10 years, my lord, 6 to 10 years. And my lord, this is
Now whether they have allowed the existing vendor to continue.
No, my lord.
Existing contractor,
Tender
sorry.
itself was cancelled, my lord. May I hand
Huh?
over the
Tender
tender
itself
itself was
cancelled and
cancelled, my lord, for
cancellation.
some discrepancies, my lord. May I hand
Now
over
who is running the canteen now? Erstwhile contractor?
Erstwhile contractor is running.
Yeah, then now when they will float a new tender, then he will participate.
My lord, there is no question
Sir,
of.
please come to the page number 2 of the report, my lord. Page number 2, paragraph number 7, my lord.
My lord, let there be a direction to file the report by way of affidavit because I can take the exception.
We are ready to file our report in the form of affidavit, my lord.
My lord, first of all, please come to the page number 3
So
of the writ
now
application, my lord.
there is no change of circumstances.
There is no change of circumstances.
There is no change of circumstances.
No, not
Tender has
Okay.
been floated right now, my lord.
No tender has been floated right now.
My lord.
So
and
there
no
is no
tender was
requirement of
cancelled.
immediate intervention in this matter.
But my lord, let them file the
File application so that you can get the matter, get the writ petition heard out in the meantime. Huh?
No urgency, my lord.
My lord,
There is no urgency
because
at all.
of this, my lord, the illegality cannot be continued, my lord. Let them.
Yes.
It's there in
My lord, may I allow to make a
my lord.
little submission, my lord?
Heard the learned advocate appealing for the respective parties of okay. The Asansol Durgapur Hospital respondent number.
This is respondent number, my lord.
We are for the state respondent, my lord.
Respondent number
Asansol 6.
656.
Sorry, my lord, this is 8.
Respondent number 8 and 9.
8 and 9. Superintendent and tender.
Who is for 8 and 9?
My lord, I am appearing on behalf of all party belongs from the state, my lord.
State up to 7.
Up to 7.
Yes, my lord.
7, 8, even 9.
9 also.
My lord.
You are appearing for whom?
State
She is my junior in this matter, my lord. She is my junior.
And Mr. Agarwal appearing?
He is also my junior in this matter, my lord.
Oh. Acha.
My lord, this
Okay.
is the service, my lord. I have served upon the Durgapur. Asansol Durgapur.
আচ্ছা আমি করুন তো হার্ড লার্নেড অ্যাডভোকেট করেছেন অ্যাপিয়ারিং ফর দ্য রেসপেক্টিভ পার্টিস আচ্ছা দ্য রেসপন্ডেন্টস আর ডিরেক্টেড টু submit a report addressing the issue raised in the writ petition as well as in the application Can 1 of 2025. So such report shall be filed within 1 week after the ensuing puja vacation. The petitioner shall be at liberty to file their response to that report within a week thereafter, leave the matter for further consideration 2 weeks after the ensuing.
My lord, may I allow to make a little submission, my lord?
Report,
little
come with the
submission
report.
before your lordship. My lord, on last occasion, on 3rd June, when I was appearing in this matter, by mistake, 4 advocates' name was incorporated in the order sheet.
Whose
Basically,
name?
I was appearing with all this junior, but by mistake there are another 4 names are incorporated in the order, recorded in the order sheet, my lord.
4 names?
My lord. Mr. Sapan Banerjee, Muhammad Ajamunda Jaman, Mr. Kushal Biswas, Mrs. Tuhena Parveen. Wrongfully, these four names were recorded, my lord.
Yeah, respondent number 1, my lord.
Today also this name have been given. This name have been given.
Respondent number 4, they are appointed by GP, additional GP.
Mr. Banerjee and his juniors are claiming that they have been appointed by respondent number 4.
I don't know, my lord, I have the engagement sheet.
That is it. আপনি রেসপন্ডেন্ট নাম্বার 4 হয়ে কে দিয়ে দেবেন, ঠিক আছে? রেসপন্ডেন্ট নাম্বার 4 এর আলাদা দেবেন। আর বাকিদের যে সবাই কিছুর জন্য ওরা দেবে, কি করবে? Two sets of advocates.
Two sets of advocates were appointed.
Says that I am appearing for the state. He is also appearing for the state.
My lord, I think
What court will do?
our name should be recorded on behalf of the Asansol District and Super Specialty Hospital, Paschim Bardhaman, my lord. As we are filing this report on behalf of them, my lord.
Asansol Hospital.
ওনার নাম লিখে দেবেন ইয়েতে। You do one thing, who is appearing for whom? You write a press. Okay. Asansol Durgapur Hospital is also under the state.
Under the state. All about state.
Okay, you write. Court will not enter into such dispute.
Deeply obliged, my lord.
ডাকুন।
Grateful, my lord.
হ্যাঁ, কত? Yes, 8.
My lord, that review, I have also filed one review
That
application.
will be taken up after the
My lord,
application.
kindly take it.
No, there is only one falsehood. The application has been filed.
My lord,
The
the
CP application is
advocate,
totally
my lord,
falsehood.
taking money. My lord, he is denying.
He is taking lie, making lie.
Yes, sir. Don't be shouted. Don't be shouted.
Where from your client?
Yes, my lord.
Oh, why?
An advocate, my lord, taking money.
Order of the whether appeal has been prepared.
No, stay has been granted.
দেখি কি দিল হাতে, আপনার কি দিল?
দিয়েছি আমি দিয়েছি ওটাই দিয়েছে বুঝলাম আপনার বলে
Sorry, Lord, your lordship, kindly pardon me, Lord, I was number 8. Lord,
Yes, your name. I have asked your junior.
his name is like that, I have already got. But I am not on that. But item number 7, my lord, actually, we are appearing for the state. However, Mr. Sahi, who is appearing for the hospital, I don't mind for that. Lordship, kindly record that he is appearing for others respondent, but state, so far as state is concerned, we are appealing. Item number 7.
So ask your junior to give a list.
Yes, yes.
You give a list afresh. I have stated who is appearing for which
My lord, my lord.
which respondent.
My
Okay. Yes.
Sorry, my lord, your lordship, kindly.
Yes. My officer will write the same. Okay.
Division.
Yes, Mr. Chakraborty, they have
Sir,
prepared an appeal.
Milord,
You have prepared an appeal.
we have preferred, my lord, 15th of September. Your lordship has the copy of the order, my lord, has got, my lord.
Yes, yes.
My lord, your lordship kindly sees, my lord.
During course of hearing,
Yes.
in course of hearing, I have been informed that an appeal has been prepared assailing the order dated such and such, assailing the order dated বার করছি বলি দিচ্ছি dated 11th March 2025.
It should be 11th
Passed in
April.
আচ্ছা passed in WPA 3308 of 2020. Item number 12.
appeal for the petitioner, my lord. The candidate to your lordship, my lord, in this matter, appeal has been preferred, it has been stayed, my lord. Appeal has been preferred and order has been stayed, my lord.
Okay. আচ্ছা আপনি দিন so go published. Yes.
With liberty to mention, my lord, as and when appeal.
আচ্ছা Mr. Chatterjee, learned advocate appealing for the petitioner, comma
Wait, Mr. Shulash. This is my application for contempt. The fight of the solely modern that has been passed and that has been communicated to the alleged contemptor, who is the School Service Commission. The order is not yet complied. My lord's order is dated 12th of March 2025.
It is for the first time.
Yes, my lord, it is for the first
Huh?
time. Yes.
The present contempt petition has been filed alleging willful violation of
Lord,
they were directed to serve a notice along with the
then said Lord.
Order for this. My lord, in this matter, my lord, I am instructed to appear on behalf of the district magistrate. My lord, the district magistrate has already convened a hearing and has passed a reasoned order.
No order has been Lord. No order has been Lord. No hearing has been conducted by the district magistrate, Lord. What happened, Lord? First day hearing was Lord called on. None was there. No hearing was taken. Second day, Lord, DLR, Lord, district magistrate, Lord, did not take the hearing, Lord. Hearing was taken by the respondent, DLR. Lord, no order has been passed till date.
Lord, I have received the order. May I then come back with an affidavit indicating the
order has been passed, has already been passed. If you agree to by that order, you challenge the same.
Communicate, no order has been passed.
You give a copy.
Yes, I will share a copy with him.
Lord,
I have just
DM has
received.
not taken the hearing, Lord, at all.
DM has passed an order. I have.
Where is the order?
But I have the copy of the order. But should I share it with your lordship?
Order has been passed. Show him. Show him. That would be.
Let me have a copy, Lord.
Yes, yes, I shall. অবশ্যই দেব
Lord, let it Lord.
Kindly take the last page, the signature of the DM. It's
My order dated no, it is an order. Proceedings in compliance with the order dated 30th January 2024, passed by the Honorable Calcutta in a different writ petition, and in pursuance with the contempt and in pursuance with the CPN.
the number maximum.
CPM is different. No, it is different matter.
Then kindly allow me to come back.
It
Kindly allow me to come back then.
is different. Writ petition number different. Contempt application contempt petition number is different.
আছি তো রে এই যে 14 নম্বর CPN 1415 তো
CPN 1415 আমাদেরকেও অ্যালার্ট করেছে
না না তোকে তো
Objection was upon the DM.
কন্টেম্পটারের হয়ে alleged contempt ও তো DM এর হয়ে আচ্ছা But I'm appearing on behalf of the alleged contempt, my lord. I have not received any instructions. I was asking my lord to keep the matter next week. Day before yesterday, we have received the brief for appearing for before you for the alleged contemptor. We did not have received any instruction till now. My lord, kindly keep the matter next week, my my lord.
Kindly keep it next week.
Next week, that means the last date.
ও তাহলে তো হবে না তাহলে এক সপ্তাহ
On 7th.
on 7th of
আচ্ছা, Every service filed on behalf of the petitioner
এটা তো তোমার নাম্বার
is taken on record. Stop.
হ্যাঁ
Petitioner,
Yes,
this is for non-compliance of the order passed by your lordship.
first time.
It is appearing for the first time. Order passed by your lordship on April 22, 2025. Subsequently, there are some
Okay,
typographical error. It was
The present contempt petition has been filed alleging willful violation of the judgment dated
20
Next.
17.
Lord, I am appealing for the petition.
Yes.
The petitioner before your lordship is a doctor, my lord. Initially, he was attached to Charnock Hospital, my lord. When he was attached to Charnock, my lord, one patient was admitted, my lord. He was not the primary
I am
consultant.
coming. You want so-called
But I want quashing of the proceedings.
quashing.
My lord. Yes, my lord.
GR case number such and such. Baguyati PS case number such and such 304A.
Yes, my lord. 304A. But I was not the primary consultant. The complaint was lodged by the OP number 2, my lord, whose mother, my lord,
304A available.
available, my lord. I tell your lordship what
Have
has
you
happened,
taken
my
bail?
lord. My lord, 2 years imprisonment, my lord. It is bailable, my lord. But they have taken bail, my lord.
Are you on bail?
I am on bail, my lord. But the OP number 2 lodged the complaint, my lord, because despite the best effort of the petitioner, my lord, the patient succumbed to death, my lord. My lord, the primary consultant was another doctor, my lord. He was not there, my lord, and at that point of time, I was visiting that patient, my lord. Now, the primary consultant, my lord, preferred a revisional application seeking quashing, my lord, and his revisional application has been allowed. Kindly comes to page number. And I have annexed.
Earlier, a application was filed on similar.
Yes, my lord. Yes, my lord. Against 2% charge sheet has been framed, my lord. I am the petitioner herein, my lord, and the other petitioner, my lord, he preferred a revisional application, and that the proceeding against that petitioner has been quashed. But I have annexed the order, my lord, page 24, my lord. A charge sheet framed, my lord, without taking any medical opinion, my lord, which is in clear violation of my lord Jacob Matthew, my lord. That kindly comes to page 24, my lord. The judgment starts there, my lord. Well, I am at the same footing of as of the petitioner, my lord, in that revisional application. The page 28 is the relevant portion, my lord.
So prior to obtaining the opinion of the doctor, the case was registered.
Prior to taking of the opinion, my lord, the charge sheet has been framed, my lord.
Even charge sheet has been framed.
Charge sheet has been framed, my lord. The FIR has been lodged, my lord, in 2018, my lord. And my lord,
The present revisional application. The present revisional application has Yes. Next. আচ্ছা উনি 4 মিনিটে রেখে দেবেন, আমি দেখবো, সই করবো, তারপর যদি ফেরত।
18, I am appearing with the petitioner.
হ্যাঁ, yes.
I am appearing with the petitioner. This is a revisional application.
ওষুধটা রেখে দিন, আমি দেখবো, তারপর সই দেবেন।
This is an applications, revisional applications.
Yes.
Against that order of the learned Chief Judicial Magistrates, my lord, regarding this, the proceedings. But there are 8 persons are accused. One Manoj, has come before this honorable court by filing a quashing of that revisional application. That application has been settled and by setting aside and quashed of that proceedings. But other persons are continue before the learned court below. Now, I have come, my lord.
What is that order?
My lord, this is the order, my lord. Your lordship, my lord, kindly see, my lord, the page C83, 83, 84. This is the judgment, my lord, of the coordinate bench. Where is the one of the, my lord, Manoj Kumar?
Now, what role you have played, what role he has played?
I mean, we are the same footing. We are the same footing.
Same footing, actually, according to the claim.
Because the one of the Jadavpur PS, my lord, PS case is initiated. According to the opposite party number 2, we file a complaint. That complaint was treated as an FIR. Then proceedings was initiated. I was arrested, and now we are all, my lord, enlarged on bail. Having that, my lord, after that, my lord, charge sheet has been submitted.
Complaint before the magistrate 156 cost 3.
Yes. Then so much of
Where
proceedings
is that
was initiated.
complaint?
My lord, complaint, that means.
Have you annexed? No.
But that is, my lord, complaint was lodged. কমপ্লেনের কপিটা আমাদেরকে দেয়নি মনে হচ্ছে না। এটা তো
You are a customer.
I'm the customer. Visitor's customer.
Eh?
Visitor's customer. Because, well, there is in a spa, is a saloon, that there are some 4 or 5 rooms. Then invited to the brothel. Well, we have not known this is a brothel. Now we are the ex-student.
Whose case has been quashed?
My lord.
What is his status? He
He is
also customer.
He is also a customer. The same footing. And all are student.
আসুন, এই রাজু, What happened? এতগুলো দিয়েছে, হ্যাঁ বললাম কটা দিতে গাদাখানি।
The case manner what happened, I'll tell you.
হ্যাঁ
On the fateful night, the victim, he was returning. Now, at that point of time, 4 people, according to the victim, were sitting there. They were having liquor. The victim was called there. The victim was made to have, was given 2 peanuts. According to the victim was given 2 peanuts and some liquor to drink. He drank there.
You want 302, a
Yes,
case
ma'am.
under 302 be quashed.
I'll tell you Lordship why. I'll tell you Lordship why. But we'll kindly come to page 16. Page 16. This is the statement of the victim.
Yes.
Please kindly see. Now, victim names 2 persons. And this occurrence. So the whole thing was being consumed by these people as well. Nothing happened to them.
No, it is a 164 statement, most probably, or 161. 161 statement of what?
His dying declaration.
Huh?
This is basically his dying declaration.
Or thereafter he's died?
Yes, thereafter he died. 19 days after this, he died. That is why 302.
Yes.
Now, my
So
lord.
what is your name?
My name is, my lord, there are 4 people. I am not preaching for the 1 and 2. 3 is Deepak Noskot and Rajkumar Gai. Now, my lord, I'll tell you that. Now, my lord, 2 names were taken. Now,
charges have been submitted.
Yes. Charges frame. That is why
Charges frame.
Challenging the charge I have come. But what happened? Now, my lord, statements were recorded. Statements were recorded. 2 names were taken of petition number 1 and 2 by everyone. Now, petition number 1 and 2 were arrested. Now, my lord will kindly come to page 23 and 24.
Yes, yes, go on. What happened?
Pages 23 and 24.
Yes.
These are the statement of petitioner number 1 and 2, the prime 2 accused, whose names have been taken by the victim as well.
Yes.
Page 23 and 24, madam. After their arrest, these 2 petitioners, the 2 accused, whose names were taken by the victim, made this statement. We mark the date, madam. 12th of August 2020.
From 161 statement, your name has come.
Yes, my name has come.
Surface.
From the 161 statement of a co-accused, first co-accused, the two co-accused, whose name were taken by the victim. They were arrested. This is the statement of one of those people, one of those accused persons. And the next page is also the second accused person. So it is only on the after that, from after that date, everyone has started taking our name.
Everyone started taking?
Our name. I mean, different way that Amra Jante Perechi and all this stuff. No one said that. Kindly come to page 25. 25 is the basic statement. Not Jante Perechi. No, 25 over the name 9. 25 or 9. 26 will come.
The father of the victim has stated that 4 person.
Yes, but name
4 person committed the murder.
But named 2. But named 2.
Yes.
Then my lord will kindly come to page 26. From page 26, my name starts surfacing. This is on 19th of August. After the confessional statement of the main two accused were recorded. So my implication is based only on the basis of confessional statement of two co-accused. And there is nothing. No recovery, nothing. My implication is based on the confession of co-accused. And there is nothing.
Ashun,
I mean,
this revisional application paper seeking quashing
does not arise. The result is that results of such statement against another person while framing charge does not arise.
Okay.
In the absence of any such substantive evidence.
Okay, yes.
I am praying for stay as in petitioner 2 and 3. Petitioner 1 and 2 I am not.
Okay, I have understood. আচ্ছা আমি seeking quashing of the sessions case number 16
my lord, the matter has been adjourned on their ground. And this is the second occasion.
Why?
Then, my lord, my lord, they are advocate in the trial court is opposing our prayer in the for adjournment in the and the court is proceeding, DW stage.
Impugn order, that means and ad interim stay. Now, impugn order, what is the impugn order?
12th April 2024, my lord. What happened, my lord? An unstamped, my lord, agreement for sale has been marked an exhibit. I filed an application for recalling of that order and to send under section 35 to send the same.
Unregistered.
Unstamped.
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 Unstamped, the court will impound the document.
That is exactly my application to send it for inquiry. Court has rejected it. That is exactly my application. It was marked, my lord, then, my lord, I filed an application to send it. My lord, kindly see my application. Kindly see, my lord, page 25. Page 25, kindly see.
Mr. Bhattacharya, you come to hard consider, peruse the case record along with such and such.
Yes.
It appears that the said agreement of sale was marked as exhibit on admission.
On admission, very well. Now, my lord, kindly see the law. The
On admission.
On does not matter. Does not matter. This is the judgment. Kindly see, my lord, it's already
the document admitted to evidence.
Yes.
Or accepted as evidence on admission. And can the person challenge the such acceptance later on?
Yes.
Yes.
And
so what is the meaning of admission?
Here, my lord, admission does not matter. Supreme Court has said, even if it is admitted, not admitted, it is the duty of the court to recover stamp duty. Court is the protector of
That is another aspect.
That is the main aspect. Yeah.
That is another aspect of the matter that cannot be. That is.
And court on that ground,
the motto of the impounding is that so that the state does not lose its revenue. Okay. Only the impounding motto. But question is regarding the acceptance. You are not concerned with the same, whether the state will lose revenue or not. But you are concerned that whether admission or acceptance of this document as evidence is proper or not. It is your main concern. But the document was admitted on admission. Admission, Mr. Bhattacharya, you know very well, admission as a result of estoppel. Admission, which admission? Admission, nothing. But it will stop the person who has made this admission.
But I have a different understanding of admission.
Yes.
Lord, admission, my lord, is a stop.
Okay, which judgment you want to say?
My lord, that is already on record, my lord. The earlier bench had, my lord, 2024.
Oh, okay, however, we are entering into the merit, but he will be killed like Obimundo. Don't do it. His
junior,
junior now impounding of document, whether it admission, it can be challenged.
Therefore, kindly passes an order of stay.
Fight to you.
Kindly passes an order of stay because in the trial court they are opposing, my lord, because High Court has not passed, and I will proceed with this suit. DW, this stage of DW.
Let them for sale.
My lord,
it is agreement for sale.
Definitely. Then, my lord, kindly passes a stay, or my lord, I will be entitled to some observation. Or
when your senior will be available? Next. Monday. Come on Monday. Hey, Monday, okay. Monday.
Tuesday.
Okay, Tuesday. When the next date has been fixed before the learned told
you, I'll immediately take instruction.
You are not taking instruction. Do you know? You don't know.
Immediately after reopening.
When? Oh, they can oh, you have got a junior also in the same way, twisting immediately after the reopening. Tell the date. In the circumstances, we can force the matter after reopening.
Very well. But this has happened. They are praying, my lord, the last two occasions.
Okay, ask your junior to take instruction.
I'll check it out.
If it is fixed on December, then we can fix it after reopening.
I'm checking it out.
Okay, you wait. You will collect the information regarding next date. Okay.
Yes,
wait. Yes.
21. 9057 of 21.
So what judgment you have brought? It is with the record. Okay, I shall see.
In this application,
Yes.
I am appearing on behalf of the plaintiff opposite party.
Oh, here also Mr. Banerjee.
Yeah,
Mr. Bhattacharya.
Yes, Bhattacharya.
What you want, Mr. Bhattacharya? To issue a rule as to the impugn order, complaint of should not be set aside. I didn't stay. What the impugn order you?
Lord, what happened, my lord, in this case, my lord, I filed an application, my lord, kindly comes to
Court finds the pair for degree of void declaration of the impugn is sufficient for the plaintiff to seek.
my lord,
No, what petition you filed?
no, kindly comes to page 20.
For
11, section 11 of Court Fees Act.
Exactly.
For ascertainment of valuation of the suit.
For ascertainment of the valuation of the
Valuation of the suit.
whether Miller, my contention with suit is undervalued and proper court fees has to be paid.
And his application was rejected.
That has been rejected.
Against that, my lord.
Now, what court has held?
The court has held that since Millard, a person Millard who is challenging the deed of gift is not a signatory Millard to the to the document, Millard he is not required to Millard give full court fee. That is the
only job, Mr. Millard, where a suit has been instituted against the for declaration. It is not plaintiff is not required to just say
Only declaration.
No, kindly comes to page 16
and yes,
prayer.
Declaration, cancellation of the deed.
Yes, not like it.
Not cancel. Kindly see page 16. Plaint. Prayers in the plaint.
Declaring such and such must be void. Void means that is such and such.
Cancellation and delivery are consequential. And that is the main prayer. He has not prayed for Miller declaration of title, and as a result, consequential for cancellation. His main prayer is Miller. Ultimately, Miller see prayer A.
And inoperative.
Therefore, that is the main prayer.
That declaration means it is impliedly cancelled.
Therefore, Miller 7(4)(b) Miller, it entirety Court Fees Act.
And plaintiff is not court fee act. 7(4)(b).
They pay the court fee.
No, it is not. I mean, plaintiff is not required to this said court fee because my lord, your lordship should instituted against the party only for declaration.
For?
Only for declaration. The deed of
100 rupees.
Yes. And 200. Should be 200. However, my lord, only one.
It is going on till now, eh? Declaration 100 rupees or 200 rupees. Now 200 rupees. Okay. Declaration.
80 declaration, 20 injunction. 100 in total 100.
Total 100.
100 plus 100, 200.
Oh.
200 Millard in Alipur Court, City Civil Court, Millard in Maforsal Court, 100.
In this case, you also can see the input order. Input order of the.
Okay. Let's Mr. Bhattacharya petition.
The cancellation, Millard, it has to be
7(4).
Yes.
For movable property of no market value. Document relating to title. Plaintiff shall state the amount at which he values the relief sought.
Seven for B minor, your lordship.
For declared degree and consequential relief to obtain her consequential.
Even my lord, this High Court judgment, there are so many judgments, my lord.
All are distinguishable on facts.
No, no.
Yes,
no,
yes.
no.
Kindly see,
Your
Milord.
lordship, I'm citing your lordship judgment, my lord.
দাঁড়ান আগে শেষ করি। Kindly see 74C and 74B.
74B.
The amount of fee payable under this act in suit next hereinafter mentioned shall be computed as follows. For now for immovable property. In suit for immovable property where the subject matter has no market value. As for instance, in the case of documents relating to title.
Exactly. This is gift.
So gift relating to title.
According to the amount to which the relief sought is valued in the plain memorial subject to provisions of section 11.
In such suit, plaintiff shall state the amount at which he values the relief sought.
If it is, my lord, for declaration of title, then, my lord, as fell from your my lords, my lord, according to his own valuation. Here, my lord, his main prayer is for virtually cancellation of deed. That cannot be done. What my learned senior friend, my lord,
now what is the meaning of 4A? For movable property.
4A, not 4A, immovable.
For movable property, yes. For declaratory degree and consequential relief, and to obtain declaratory degree and order where consequential relief is paid. So according to them and according to the court, this case will fall section 4, section 7, 4B.
Exactly.
Yes. 4B.
Yes.
You are also saying that 4B.
No. I say it has to, my lord, he has to give full court fee because he prays for cancellation of the document. He prays for cancellation of the document. I am covered by a judgment on this.
Yes, so.
Your lordship can also discharge.
Okay, I'm coming.
I know all these judgments. I'll distinguish those. Milord, I hope, Milord, Justice Showman's judgment, Justice Shubhra Kamal Mukherjee's judgment. Yes. I'm aware of. Kindly see paragraph 15 and 16.
15 and 16.
Yes. Oh, যেটা rely করা আছে. হারা মামলা আমার
সুপ্রিম কোর্ট হাইকোর্ট থেকে বসে শুরু
Yes. Yes.
Now, Milord, two things. Milord, I understand my learned friend's submission. Milord, if Milord, suppose suit for declaration of title, that is the main prayer as a consequence cancellation of deed. Then, Milord, my learned friend is clear according to his own valuation. But here, primary relief is not for declaration of primary relief is cancellation of deed. Primary relief. That is the primary relief. Because null and void means what? It has to be delivered and cancelled. Section 31 of the Specific Relief Act. Therefore, primary relief is cancellation. He has to pay it, Milord, according to the own valuation. According to the valuation of the document.
Yes.
In this case, my lord, your lordship, this is the input order first. Order, 27th September 24. Consider the above submissions, peruse the materials on record, plaintiff of the plaintiff, which has equal ground for the non-effectiveness of the said deed of gift. It is stated that same is void as being vitiated by fraud, coercion, etc. The plaintiff also narrates a checkered history of complaining against such mischievous act of the defendant number 1 to various authorities as well. Now to opine, this court finds that plaintiff, though failed to play any relief in respect of the declaration of title, no prayer, but the same can be figured out from the plaintiff itself. Degree of void declaration can be played by a party plaintiff if the documents gets vitiated by fraud, coercion, etc. Even though the plaintiff is a party to that particular thing, it is not a party in the particular thing. Document stands as void. This stands void ab initio, so no question of avoiding or salty arises. But in the case of cancellation, the document stands valid at the first, wherein the plaintiff seeks to avoid the same because of certain reason for non-complying of any term and condition of the safety and or whatsoever as the case went out to. This is a matter of adjudication for time. This will be decided. With such objection, the court finds that a prayer for degree of void declaration of the instant deed of gift is sufficient for the plaintiff to seek for the present cause as penned out through the features of the instant claim. There seems no requirement at this stage, at least as appears to go for prayer for cancellation of the instant deed of gift from the part of the plaintiff of this suit. Hence, there seems no further requirement of assessing of ad valorem court fees on such prayer of void declaration.
Okay, you go. Don't read entire. Come to the year. So main question is that here plaintiff prayed that the deed of gift is null and void. Okay. Now the plaintiff claimed that I have sought for a void declaration. It is a new term has been coined.
To avoid court fee, not
avoid court fee,
not cancellation.
It is actually if a document is declared by a court of law to be invoid and inoperative,
Delivered up and
that
cancelled.
means it would be ultimately cancelled.
Section 31 of this
Question of
specific
your lordship is the prayer. Degree be passed, decline, not title.
Yes, I have seen that void and inoperative come to shorten the litigation.
Clever
Okay, area of litigation. Okay. Now, main thing whether the deed of if anyone filed a suit seeking a decree of cancellation of a instrument of a deed of gift or deed of sale, whether he is required to give ad valorem court fee of the value of that value mentioned in the deed, value of the property, or it would be treated as a mere suit for declaration simplicity.
Same point and
Yes.
the other side, my lord.
Yes.
In this case, my lord, whether proper soldier or
Citation টা দিন, citation টা।
page.
Citation টা বলুন। Oh, Justice Mukherjee, I know. I'll distinguish.
61 CHN.
61 CHN 526.
And another also, my lord, Justice.
একটা দেখো CO 4601 of 2015. হ্যাঁ জানি।
This is a plaintiff claim. This is a suit for declaration simplicity and relief of setting aside the deed is consequential.
Exactly, consequent. In that case, Milord, it is not required. Kindly see paragraph 2. That was what I am saying.
The suit has been properly valued. Proper court fees have been paid. The defendant may believe and may not be proper court fees are continued.
ওটাও আছে, দিয়ে দেবো আপনাকে।
Whether proper court fees are paid on the plaintiff is primarily a question between the plaintiff and state. Same thing as the learned judge in lower appellate court rightly held that the suit has been properly valued. Here suit for
Declaration.
Declaration.
Title.
Now,
Paragraph
no,
2.
Suit for, no. Suit for declaration and injunction. Your logical is the
Declaration of what?
plaintiff. Your logical is the first. Suit for declaration, page 2, 9, page 9. Suit for declaration, permanent injunction and other reliefs.
no, a pair is total different.
Those are
Here suit was filed. Here suit was filed seeking declaration of title, and for a declaration that the deed of gift is false.
That is consequential, really.
And no title as transferred by the document, and setting aside the deed, and a further declaration that the defendant had no sellable interest in the property.
Exactly.
So suit is suit for declaration that the petitioner has a title in respect of the suit property.
No,
Another declaration was sought for that the deed of gift, deed
Null
of
and
gift
void.
is fraudulent and false, and no title has been transferred to defendant. Another consequential setting aside that, so it is distinguishable in fact.
My submission will be that plaintiff is not required to value the suit because no title or any other card, only clearly
That is
void.
Void. That means essentially is a
What's
suit
the
for
meaning?
cancellation.
My lord, what is my should if suit only for this to pay the court fees, not other purpose. At the time of my did you logically see the his application? What is his application?
If you refuse to pay the court fees, then he file an application order 7 rule 11 A na B
After
rule 11 B.
order 7
undervalued.
He is preparing the gown.
Relief claimed is undervalued.
This
He
order
is preparing the gown. Next application will come.
I'm helping him.
Actually,
because the order.
Actually, if sufficient court fee is not paid, is despite being directed to do so, then the suit will be dismissed. So he is preparing a gown.
Everything will go.
What he will do?
Lord, I'm reading Millard section 31 of the specific relief act. If your lordship sees, it says any person.
Give the book. Have you brought the book?
I'm extremely sorry.
My lord, your lordship also, my lord. Kindly see the judgment, my lord.
A judgment, facts will change judgment.
No, you take it. I am trying to.
Okay,
I am trying to.
Section 31.
আমি এখান থেকে বার করছি ওরা কিছু না কোর্ট
তুমি কেন রাজি করছো
হ্যাঁ হ্যাঁ বলবো এক্ষুনি বলবো এক্ষুনি বলবো kindly see Millard, any person against whom a written instrument, this is a written instrument, is void or voidable and who has reasonable apprehension that such instrument, if left outstanding, may cause him serious injury, may sue to have it adjudged void or voidable, and the court may at its discretion so adjudge it and order it to be delivered and cancelled. Therefore, it has to be cancellation. Only declaration void and voidable will not do. Therefore, the ultimate relief is for Millard cancellation. Then Millard kindly see 2. If the instrument has been registered under the Indian registration, the court shall send a copy of its decree to the officer in whose office the instrument has been so registered, shall take a note of this such cancellation. Therefore, one says only declaration you will not do void or void. Court will, that is the language, adjudge it, order to be delivered up and cancelled. Cancellation and deliver. Ultimately, by a clever drafting, it has been only said declaration that this is null and void. No, that is not the law. This is not applied to avoid court fee. If his main prayer was section 11, was declaration of title, I had no case. His main prayer is for cancellation.
Yeah, main prayer is that declaration that the deed of gift is cancelled, because deed of gift which was procured by the another son. Here, my lord, only my lord, your lordship kindly say only another judgment, my lord.
Justice Sen.
That is said.
Oh, same distinguished.
Page 9, my.
601 or 15.
Your lordship at page 9, in Novokumar Das versus my lord Damodar Das was created. The issue arose whether the issue for declaration that the deed of gift null and void, valued according to the valuation given in the plain, or plaintiff would be required to pay attorney court fee on the value of the property covered by the deed. The plaintiff petitioner instituted the for a declaration that the deed of executed by the father of the plaintiff, number 2, paper of the number 1, the nullity and void, and he is liable to be cancelled, and for injunction, alleging that the number 1 obtains the statement by
Far from your reading.
Page 9.
Page 9.
Page 9, yes.
A top mother in Novokumar Das.
Yes.
The suit. Objection regarding the valuation of the granted judge by the judicial order direct the plaintiff to pay requisite court who is setting the value of the property covered of the deed. As the opinion of the court, plaintiff really wanted to say the deed of gift under the capital order, the decision was moved against the front. And last, my lord.
উমাপদ জটি তো নামটা? না আর দাঁড়ান এটা দিয়ে আরো আপনাকে বেঁধে দিই, এটা দিয়েই আপনি নিজেই নিজের বাঁশটা নিয়েছেন, দেখি দাঁড়ান না।
Okay, only these two judgments are there
Here, my lord.
on the field. Any other judgments are there?
I have relied upon one judgment, Justice Prosenjit Mondal's judgment.
Only one. Judgment, my lord, 9 and 10. The Honorable High Court, my lord, 2002 CIJ, 2006 Constitution. Forest Chandana. 9 and 10 paragraph. Forest Chandana, 19 paragraph.
Forest Chandra Nag.
Nag.
Justice Subrakal Mukherjee.
Yes.
9 and 10 paragraph. Same case.
Yes.
The plaintiff claims that the defendant number 1, who is the brother, had allegedly obtained the deed of gift of him fraudulently giving the plaintiff an impression that the plaintiff was executed power of attorney in favor of the defendant number 1 for protecting the boundary of the land of the plaintiff. This for declaration simply step and the relief for setting aside that deed is consequential.
Yes.
Consequential. From the careful reading of the plain, it is clear that prayer for declaration that the defendant number 1 obtained the detail by practicing force on the plaintiff with the substance of the claim. 10. Whether proper court fees are paid or paid is primarily question between the plaintiff and the state. The learned judge in the lower appellate rightly held that the suit has been properly valued, proper court fees have been paid. The defendant who may believe, even honestly, that proper court fees have not been paid by the plaintiff has still no right to move the superior court against the order adjudging payment of court fees.
Okay, heard the learned advocate.
Only one
for the-
short reply. Well, kindly see Millard this judgment only.
I'm keeping it under for orders.
Yeah, no, only one short reply. Kindly see Millard. Kindly see Millard. I have perused the averments made in the plaint. The substantive relief claimed in the first declaration consequent, which the right flows directly from it. The consequential relief claimed in the suit cannot be claimed independently. The consequential relief in the suit that is for setting aside the deed. Well, kindly see Millard, paragraph 8 once. The consequential relief claimed in the suit that is for setting aside of the said deed will not independently unless the relief claimed for declaration is prayed for. Therefore, he has not prayed for declaration of title. He has only prayed for cancellation. Millard, I am praying, Millard, Lordship can suo moto exercise order 7, rule 11 and dismiss the suit here and now. He has only prayed for cancellation of and Justice Mukherjee says it will independently not lie unless but Lordship kindly exercise order 7, order 7, rule 11D, dismiss the suit here and now.
Unless there is a jurisdictional error, then why not?
Kindly
Mr.
dismiss.
Bhatta had the learned advocate having
Kindly dismiss the suit here and now.
APTV service টা নিয়ে নিন, APTV service filed on behalf of the $323. Come on, Tuesday.
Or 3rd November, if your Lordship so wants, I can come back on after vacation also. 3rd of November. We are opening on 24th.
Oh. Okay, in that circumstance, 27th October. 27th October.
It's a Monday.
Other matter 27th October.
It's a Monday.
27th. Hey, 27th October.
To Millard and there Millard praying for Millard after vacation.
Okay, after as prayed for on behalf of the petitioner, it is the matter for further
It is
consideration
Millard in
after
December, Millard in trial court.
after ensuing puja vacation. Yes. 1 week after ensuing puja. 2 weeks after puja vacation.
2 weeks, 2 weeks.
23, yes.
Just a snort, he's gone to the washroom. He had come.
Yes,
Only
yes.
got- Just 23, 24 only passes.
Yes. 25,
Right.
yes.
This is an assigned civil division before Lordship's court.
Lordship, I'm for the opposite party. I'm led by Mr. Shauradipta Banerjee. He is engaged in another court. Kindly grant me a short pass over.
Yes,
But there is a direction to file their affidavit. They were supposed to file their affidavits.
You file affidavit?
I shall file affidavit. Kindly extend the time.
Direction was also given.
Direction was there. Lordship kindly sees the Lordship's last order. Lordship will kindly see the Lordship's last order.
Some order.
The order was passed. The time has lapsed.
Okay. Oh. আপনি ইয়ে করুন মিস্টার আসুন মিস্টার দেলানেট অ্যাডভোকেট অ্যাপিয়ারিং
Small background. Final report was given.
Huh?
A final report was given.
Yes.
Now, against that final report, Mr. Bhattacharya's client moved the magistrate. The magistrate was pleased to direct 173(8). Against that, we moved the revisional. Then the revisional application was dismissed. Then we have come before your lordships. After that, under 482.
Revision application before the session judge.
Yes.
Session judge, yes.
So, Malad,
That was dismissed,
and-
challenging the order, you have come here.
Now, Malad, Mr. Bhattacharya has also moved an application by which he has asked for investigation to be done, investigation to be done properly.
Investigation to be done properly.
So these are two applications which are pending.
Investigation, further investigation.
Further investigation. So, Maharaj, this matter will take some time. So, Maharaj, I was suggesting, subject to Mr. Bhattacharya, Maharaj, he has a prayer, I have a prayer. My prayer is no coercive steps. His prayer is report in final form should not be given without the leave of the court.
Or till this application is disposed of.
Till the application is disposed of.
The final report should not be filed by the investigating officer.
Officer without the leave of the court.
Without the leave.
Okay. So I'm passing that order since
Yes.
both of you, at least on this point, has reached to a consensus.
Yes.
Consensus.
Till the disposal of these applications, just application and my application.
I'm in 23, Malad, for the state.
43 on behalf of the state.
Yes. And he is 23 for the state.
Order.
Same order, বলে ফেললো, combined order.
Combined order. It is with.
Combined order.
Combined order, yes.
Grateful, man.
Yes.
Item number 26.
26.
26, my lord, I am for the petition. My lord, this is appearing for the first time. My lord,
So you want notice?
My lord?
You want notice?
No, my lord, I am praying for a stay, my lord. That this
Stay, expertise.
revisional application, my lord, it's against an
Here
order.
for stay of operation of the interim order and title execution.
Yes, my lord. Allowing the order, allowing the execution of a decree, and my lord, issuance of writ for delivery of possession. Now, my lord, what I am contending is that the decree is not yet matured for execution, my lord. Now, I will show, my lord.
Decree for?
Well, decree for
Eviction.
Eviction, my lord.
So why it has not matured?
But subject to repayment or refund of security deposit. That refund has not been made, my lord. My lord, if my lord is pleased to take up page 104, my lord, of my petition, it is the main ordering portion of the decree under execution, my lord. My lord, the page 104. My lord, this
is the main degree.
This is the main judgment and decree, my lord.
It is the degree. As a degree of consent against the dependent number one, subject to payment of the security deposit.
Yes. And the
amount in her favor, while her counter claims stand dismissed, subject to payment of security deposit by whom?
By the plaintiff, my lord. My lord, the security deposit. Oh, that's the defendant. I'm not defendant.
Oh, when the date has been fixed by the executing court.
My lord, the next
date?
10th of November, my lord.
I am keeping part to that.
My lord, already
10th of November, I am keeping fire to that.
Protects my possession.
No, yeah, before that, nothing will happen. Okay.
Already bailiff has visited the property, my lord. Now, what remains is only the police help. So, my lord, kindly protects my possession as such.
If whether they have filed any application seeking police help, then also a hearing will be given.
Till date, no application has been filed.
Till date, no application has been filed.
No, my lord. But the bailiff has already visited. That is the last straw that is remaining, my lord. My lord. My lord, may I show page number 124, my lord? This was an order, my lord, where...
How many? 2 lakhs?
2 lakhs, my lord. Where specifically...
Adjustment of 2 lakhs from the monthly rent in respect of suit premises as fully...
My lord, kindly looks at page 124, my lord. 124. The very last line is of relevance, my lord.
Whether bailiff has been directed.
Yes, my lord.
At what stage the executing proceedings is now pending?
Bailiff report has been filed. Bailiff report has been filed.
You show the order sheet.
Well, that order.
You have not that order sheet as well. The title execution case number such and such.
This was filed prior to the bailiff report, my lord. Whether the amount has been actually paid or not, that investigation has not at all been made. The court simply noted that as they have sent a letter and sent a check as per their contention, that's why they have complied. Whether the check has been at all encashed, that has not been gone into.
You raised this point, you filed an application under section 47. You raised this point before this court. On consideration, I find a banker check such and such issued by the Bank of Baroda on Otho. Execution case was filed on Otho. Naturally, the degree holder has failed to fulfill the second condition. But it is to be noted that the judgment has not handed over the vacant possession of the sought property to the degree holder in execution of the degree on the plea that he has not received the banker checks. It appears from the record that the judgment debtor appeared in the title by filing the appeal was pending before the High Court. Therefore, initially the execution case was stayed by the, ultimately the appeal that it was dismissed. Therefore, title execution was heard both party. So your payer has been here, bank has been already issued a check.
They have drawn that check, but they have not sent it to us. That is why, my lord, I was showing page 124 where they were it was specifically directed that whether the check has been encashed, whether the payment has actually been made, that should have been looked into. Page 124.
The present divisional application has been prepared challenging the order dated 12th August 2025 passed in title execution case number passed by the learned your possession is now you want to use as your security to get that amount. Okay, now you want to continue your possession over the suit property or dignital property only as a security of that amount. Court will take care of that.
But
Okay.
my lord,
Yes.
my lord, may I just
But
but
a
that
banked up, what is mean banked up? The amount has already been deposited
in the bank.
In the bank, so it is not in its possession, only in the bank. Bank has issued a banked up. So it is the responsibility of the bank to honor that banked up.
My lord, it is also a fact, my lord, if they are sitting tight on that bank.
Okay, let them come on.
They can recover that money from the bank.
Okay, court will take care of. You are only concerned with the money.
And the decree as such becomes premature, my lord.
Oh, okay. Let do this. Okay.
Kindly.
Degree basically for recovery of the possession. But there was a condition. Before that, they subject to the payment of certain amount.
Precondition.
Subject to the payment of. Use of what subject to, you may claim that it is a precondition. So unless that condition is fulfilled, degree cannot be. The court has taken note of the fact that the degree holder has already deposited certain amount against which a banked up was issued. Banked up also sent to you. But you are claiming that I have not received the same as yet. So there is a question of fact. There is a question of fact. Money has already been deposited by the degree holder.
But
okay,
kindly consider.
So let them come. Let them come.
Given the date of the bank draft, that is, as on date, it is expired.
Okay, now since
automatically the bank will refund the money.
Since a court of law, a civil court of law, after evaluation of the evidence past and degree, you preferred an appeal against that degree before a honorable division bench of this court. Degree has been affirmed. Now the only concern, your payment of money.
No, my lord, that is pending. Appeal is pending. Initially, we got a stay, then the stay was done away with. Appeal is still pending.
No.
Yes, my lord.
You read the. I didn't.
No, my lord. Appeal is still pending.
Oh.
I am appearing in the appeal, man.
So why you are coming here?
Well, this is against the execution, man. This is
You
against
go to that court, the stay of the order. Read that. Come to internal page 6.
Yes.
1, 2, 3, 4, 5, 6. Ultimately, the appeal being FAT 181 of 2024 was dismissed on contest by the Honorable Court. By order dated 17th February 2025.
Only the can, my lord. Appeal is still pending. It is my personal submission.
Why not you have filed an application for modification or recalling of the order or observation
that was just
before the learned court below?
For the stay of the decree, my lord.
Come on that day.
Appeal is.
Come on that day. Don't stand in the way. You are only concerned with certain amount of money. Okay. Don't give the possession. Your payment of money will be taken care of. Okay. Your concern about the money will be taken care of. But showing the same, citing the same, you cannot go on enjoying the possession. Okay.
I'm grateful.
Next.
27.
27.
My lord, there was a direction for service of this application, my lord, which I did. Whereas my learned friend is appearing for the state. My lord, this petitioner, he is an employee of Steel Authority of India.
Yes.
My lord, he took out an application for return of the documents which were seized in connection with this case. My lord, that payout got turned down. My lord, may I just inform your lordships, my lord, he was booked.
You want quashing?
No quashing. My lord, for one.
3492 of 2025.
My lord?
Susanto Vishwas.
Yes.
Please to set aside quas recall of the order that
The order
passed by the
or the proceeding of the order.
connection with that arising out of which order was passed?
My lord, the order.
14A, there is a 14A Foreigners Amendment Act
Yes.
also. Yes.
Yes.
Foreigners
My lord, there is
Amendment.
an allegation under section 420, 120B, 14B of A,
You
subsection
have
B
forged
of foreign.
the voters card, identity card or testimonials.
My lord,
What is the allegation?
allegation is of using forged documents.
So
that is fine. My lord, for once, may I take your lordship once to the order passed in the bail application, page 17, annexure P1.
28.
Order dated 20th June 2025. My lord, kindly sees this petitioner was granted interim bail immediately after his arrest within 10 days. My lord, page 17. My lord, got it? Page
You are Indian citizen or Bangladeshi national?
I am an Indian citizen.
Oh, what is your address?
I have given the address. My address is, my lord, kindly comes to page 2 of the nomenclature.
Newtown. Okay.
Paschim Bardhaman.
Oh,
Kanpur.
that is Paschim Bardhaman.
Yes,
There is also,
because I am an employee of Steel Authority of India.
so you have challenged the order dated 28
By
June.
which the London magistrate were pleased to reject my prayer for return of the seized documents, that is the Aadhaar card and my identity card. My lord, I am just indicating to page 17 because there is an observation made by the London magistrate while granting interim bail to me. My lord, page 17 for once kindly comes, that is order dated 23rd June 2025.
It was seized in connection with that case.
Yes. Now, I was granted bail principally on the ground that at the time of my employment, there was a police
Charge sheet has been submitted.
Nothing. Now, charge sheet submitted. Very good. Very well.
Submitted.
Yes. Now, my lord, kindly comes to page
So,
18.
Allegation is that those Aadhaar card and
No, I am a Bangladeshi national.
those,
That is the allegation.
Allegation
Now-
is that those Aadhaar card and voters identity card are forged.
That is
Allegation is that.
Exactly, that is the allegation.
Yes. Now, if it is handed over to you, whether you will, what is the guarantee that you will not misuse the same?
No, there cannot be. In the first place, there cannot be because in the first place,
Till date, it is a great question mark whether you are citizen of our country or not.
yes, my lord, may I just
That investigation is going on.
may I give answer?
Now you showing certain document claim that you are a citizen, Indian citizen, not foreigners.
Perhaps it is not the case of the prosecution even. My lord, may I just give answer to each and every query raised by this honorable court?
Kindly see the verification report of the EPIC card, the last paragraph.
My lord, before I placed my case,
Yeah, Susanto Vishwas applied for detention. On the ground, he is not Indian citizen. Accordingly, his name has been deleted from electoral roll. He himself claimed that he is not the Indian citizen.
I have submitted that now.
no, I have claimed it before the investigating officer. That is my confession.
You yourself apply, seeking a shelter in the detention camp.
Oh, my lord, now all the bishops from that area and Nodia, they are taking out this application. My lord, may I kindly do not allow me to at least, my lord, to get into this kind of debates. My lord, because of this SIR and all what they are doing, these bishops from this part of the of our state, my lord, from Nodia, from this part, what they are doing, why they are taking out these applications. I have nothing to say on this because I have also a notification from the government of India which declares otherwise that the persons who are from our neighboring state and they are here, if they are Hindus, they are citizen of this. My lord, I am not on this. I am principally on the legal point only. My lord, can you allow me to at least ventilate the legal grievance of this person before this honorable court? My lord, if you also want me to come back at 2, my lord, I am. Because I find, my lord, the papers which he has annexed, my learned friend has annexed to these applications, my lord, at least makes out a case that he should be at least allowed to stay alive. My lord, one cannot, my lord, Article 21 otherwise says that it is applicable for each and everybody, irrespective of the fact that whether he is Indian or a foreigner. When a person, he claims that, and there is no denial to the fact that he's an employee of Steel Authority of India, and where his suspension is withdrawn by the Steel Authority of India, immediately after his grant of bail, my lord, if he is denied with these documents, my lord, that otherwise gives rise to a fact that he will not be allowed to join his office. My lord, he will die. My lord, this cannot be, because my lord, there are other cases also pending before this honorable court, before the honorable Supreme Court relating to this. And when a person, my lord, he comes and says, I takes out an application saying that no, I am a Hindu, I belongs to a particular religion that is Hindu. My lord, the notification otherwise entitles him to be part of this country. I am not into that debate at all. But my lord, so far these documents are concerned, my lord, can we consider this, whether these were considered by the learned magistrate at the time of passing of this interim order. Because the first order granting me bail and subsequent rejection are, my lord, that will amount to recalling of the first order.
What is the report? You sent the Aadhaar card and voter card for verification?
My lord, the voter application verification report is yet to arrive, and my lord, the voter application report. Initially, my lord, he enrolled his name in the voter card in the constituency of Ranaghat, my lord. That application has yet to be verified, my lord. That report has not come. And my lord, regarding the caste certificate verification report, that is also pending, my lord. That could not be traced till date. And my lord, regarding the his voter electoral name in the Asansol constituency, my lord, that just I have showed before your lordship. And my lord, one more thing is that before their application dated 27th of July, my lord, which they have challenged that order. Before that, my lord, their application for return of documents were rejected by the learned court below.
Yes, that is there. I find, my lord, that
the document has been returned.
No, my lord, not returned.
Yes.
This was the subsequent application. Previously also,
my
their
lord,
application
on
for return.
second,
The court refused.
yes.
Again,
took out the similar application. Yes, my lord, that will not stand in the way, because my lord, even your lordships can also take into account. Now, my lord, section 22 of the Indian Penal Code. My lord, kindly see. My lord, may I come back after 2?
Section 22 of
the Indian Penal Code, it otherwise entitles me to get these documents, because this is a property. And my lord, this is a movable property and it's a corporal in nature. Therefore, it entitles me to get 22 otherwise entitles. Oh, আমি তো তাই বলছি, may I just come back?
Come on Monday. Come on Monday.
My lord, Monday.
Yes, true. Yes. It may continue or it may not. Today,
No,
today
today is 3:30
one side. Yes. And you come on Monday. Okay.
No, my Monday.
Okay. Yes.
Very short.
Yes.
I don't know, 59. But Lordship may have the complaint first at page 41. The Lordship would have page 42. The accused number 1 is PepsiCo. But accused number 2 is the present applicant before your Lordships. 3, 4, and 5 are other officials of PepsiCo. So, my lord, 2, 3, 4, and 5 are all officials of PepsiCo. The allegation by the complainant is that I was appointed distributor and there was a money dispute and PepsiCo did not pay me money for that dispute. That is short allegation. If your Lordship would have page 59,
Who is the complainant? The OP number 2.
OP number 2.
OP number 2 is the complainant.
He is the complainant.
What is his allegation?
That he was appointed distributor for the company. Lord, company is in soft drinks, the beverages, Lord, and for Calcutta area, where, my lord, he
PepsiCo company. PepsiCo.
PepsiCo, Lord, PepsiCo.
Yes.
My lord, they have brands like Pepsi, Mirinda, and all
Yes,
these brands.
yes.
So he was appointed distributor. He continued to be distributor for 3 years. His distributorship was terminated. And after termination of he filed a complaint after 3 years saying my dues have not been cleared. That is the criminal complaint. But other accused approached this court. Page 59 is the judgment.
Criminal revision.
Lord, there were 2 separate criminal revisions, one by PepsiCo, other by the co-accused. Lordship would have, Lord, page 59 is the judgment of this honorable court. Paragraph 9 will be relevant, page 62.
In respect of those petitioners who approached the court.
Approached the court.
The case was quashed.
Yes. So, my lord, he is one of them. There is no special allegation against him. He was also official of the.
Stand on the same footing.
Absolutely same.
The patent division application has been prepared seeking quashing of the complaint. Bearing number CN 005341
Next matter at 2 p.m.
So, Mr. Bhattacharya will take whole day today.
Well, we are planning not to take so much of time. If your lordship kindly fix it after the vacation. Treating this is hard today.
Hard and
these are all secret understanding.
Yes. It has already been made Patha. Oh, today Patha. Yes. Yes, Mr. Bhattacharya.
আজকে হাজির পাঠ হয়ে গেল তো হবে কি? On the last occasion, I was on the agreement for operation. That was at page 240-41. এটা হচ্ছে এইটা আমারও গন্ডগোল হয়ে যায় গো 2966 page 240
Oh, এটা নয় Yes, page 240.
আর রাত 10টার দিক থেকে ফিরেছি তারপরে
এটা একটা ক্যান তো নাকি
হ্যাঁ
ও
আমাকে
পেজ 240
ইনস্ট্রাকশন দেয়
Yes, Mr.
Remember, this was an agreement between the government of West Bengal and the petitioners Tannery Association and the conforming party is Dalmia, who is also represented. My lords will kindly turn, my lord. I'm just placing the relevant 2-3 paragraphs of the said agreement. Clause B, whereas the objective of setting up of the CLC government of West Bengal has selected a suitable composite site spread over Moja so-and-so, which is Moja so-and-so, leather complex containing by at measurement area of 1100 acres with the same and little more or less adjacent to State Highway, Bashanti Highway. Then government of West Bengal had also decided that CLC would be implemented to facilitate relocation of the existing tanneries at Calcutta to operate in a pollution control manner at the complex. B, to develop the complex as a modern export-oriented leather city.
to assist the leather industry in West Bengal to grow and prosper in the future. Now, this is the basic foundation of all, my lord, action taken pursuant to the judgment of the Honorable Supreme Court. Well, I had placed the Honorable Judgment of the Supreme Court, and that judgment lot has universal application, so too, or a pan-India application. I have shown that the Kanpur, Tannery and others, they were also shifted. Then in the background of the above, by a memorandum of understanding executed on the 5th so-and-so, the erection, construction and completion of the CLC project to the confirming party, pursuant to which the confirming party submitted its DPR, which was supplemented and revised from time to time, and the revised final abridged version of the DPR, so and so. I am not traveling, my lord, with that. Then kindly come to, my lord, G. The most happy person in this litigation is Mr. Amitesh Banerjee. He is representing Dalmia. I have nothing to do but to stop here. The Honorable Supreme Court.
Yes.
I was speaking in your favor. Still, you are.
Yes.
The Honorable Supreme Court of India, in his judgment dated 19 December 1996, had directed that the tanneries working in certain areas of Calcutta were to be closed down by a certain date and relocated in the CLC, and Government of West Bengal was to offer them land which was to be not less than the land compatible. I am not troubling my lord with the several paragraphs which deals with the Honorable Supreme Court judgment, which was extensively placed by me. Then my lord, kindly come to paragraph K.
Paragraph?
K, subparagraph K. I am the paragraph K of the agreement. The agreement dated 7 June 1997 between Government of West Bengal and confirming party inter alia recorded that till date, 584 applicants had been received from relocating tanneries along with 25% deposit as ordered by the Honorable Supreme Court of India. However, out of the above applicant relocating tanneries, only 523 tanneries have since paid the full amount of the cost land as per agreed payment schedule and so and so. Now, these are place. I have also mentioned on the earlier occasion that the lands were not a freehold land for us. We had to pay the price and get the allotment. Then kindly come to T.
Yes.
CLCTA has also represented to the Government of West Bengal that they have obtained an undertaking as per pro forma enclosed from the majority of tanneries to be located with CLC, including relocating the new tanneries, that they agree to the role of CLCTA for maintenance, for maintenance and supervision of the above mentioned infrastructure, and CLCTA would henceforth act as the representative of the tanneries with CLC for maintenance of the above infrastructure and for dealings with Government of West Bengal. Therefore, the maintenance of the infrastructure was the responsibility of CLCTA, my client. And yes, S is also important, Lord, as is pointed by my junior. In order to take charge of the administration, repairs and maintenance of such infrastructural facilities for the tanneries, certain tanneries have formed a company, namely CLCTA, with an authorized share capital of 5 crore and initial paid up share capital of 3 crores, and CLCTA has represented to Government of West Bengal that it will, as representative of all the tanneries operating with the CLC area, that is the relocating and the new tanneries, be responsible for administration and so on. So that is with regard to the details of the taking charge of the infrastructural administration, which is not in dispute, and I hope still they will not dispute that.
Then kindly come to the 252 page, operation of infrastructure assets. Clause 4 পড়ার আগে আমি 3 একটু পড়ে নেব। The 3 is important. I am not reading the entire. It is page, clause 3 starts from page 251. Pagination means it is hereby recorded that the common effluent treatment plant. Yes, my copy is little illegible. Yes. No, Joshua copy ঠিক আছে.
Yes.
Legible.
Effluent treatment plant, which was originally
planned in 6 modules, has been completed only in respect of modules 1 and 2 and modules 3 and 4 are in an advanced stage of construction, while the construction of modules 5 and 6 is under progress. The CETP is being constructed with funding by Government of West Bengal and the Government of India for modules 1, 2, 3 and 4, and with funding by Government of India and the conforming parties for modules 5 and 6, and is now in an operational stage in respect to the first 2 modules. Then CLCT hereby undertakes that it shall ensure that all tanneries in CLC shall comply with all effluent treatment norms and effluent discharge norms, and shall comply with all lawful directives given, and ensure that all tanneries in CLC comply with lawful directives given by the pollution control authorities and by the water irrigation authorities of Government of West Bengal. Therefore, the responsibility of maintenance and the maintenance standard of pollution is ultimately with the CLCTA. If any violation would ultimately put me under the penal clause, it will not put either the Government of West Bengal or anybody under penalty. Yes. CLCTA also undertakes that it will ensure that all tanneries arrange for pre-treatment facility for primary treatment of the effluent within its tannery as may be required in terms of the approved technology and design of the common effluent treatment plant, and shall, to the satisfaction of the West Bengal pollution control, maintain, comply with all norms and regulations that may be required in terms of the said design and technology and statutory requirements of the West Bengal Pollution Control Board. CLCTA shall also ensure that all tanneries also make arrangements for segregation of chrome effluent from other effluents within their respective functional areas. CLCTA shall ensure that no water and or effluent of sewerage is split outside the premises of the tanneries or any tannery so and so, so and so. CLCTA also undertakes to effect the individual effluent sewerage correction from individual tannery. But if I am the ultimate person to be responsible in all aspects of maintenance of that effluent plant, and I have been doing so, what prompted you, in the name of creation of a development body, to denude the CLCTA from maintaining the effluent plants, which ultimately would affect them? Suppose 10 years hereinafter, there are fault on the part on maintenance of the effluent plant. The government agencies will go on writing letters from this department to that department. But who suffers ultimately? The tanneries. The tanneries have once suffered relocation on the ground of pollution. And therefore, we are very much scared of maintaining the standard of pollution so that we are not ultimately put into trouble. We are apprehending, and apprehension has a genuine foundation, that in future, any difficulty with regard to maintenance effluent plant will again ask me, you go beyond Baruipur. The leather complex which has been created, and definitely which is doing good business, and that also gives benefit to the state revenue. And this is our, my lord, main grievance. But I will stop here today with due affection and dealings of Mr. Mitro and my friend. And nobody will object me. Nobody is in the mood of doing a long matter. Join to that.
Okay, আসুন।
Now, 10 minutes. পাঠের তো হবেই। আগেই করা আছে।
Are the learned advocate appearing for the respective party leaves the matter for further
এটা
consideration?
অসুবিধা নেই। যারা
When?
আছে others এই হেড নিয়ে অসুবিধা নেই। তো সবার
When after vacation, when on which date?
এইটাই।
স্যার কবে থাকবে?
First Friday.
First Friday, sir, court
The first Friday of the November.
Yes.
On 7th, এই 7 এ দুটো 2 PM এ কিছু আছে মিস করেছি?
দেখছি
ক্যালেন্ডার দেখে বল না জল
সাথে সাথে। ও সাথে।
7th?
On that date, I have a different bench, division bench.
7th?
No,
7th Friday.
Sir, 14th court.
এটা জজ সাহেবের কনভিনিয়েন্স দেখতে হবে।
14 আছে নাকি? 14 ডিভিশন বেঞ্চ আছে? হ্যাঁ? No, 14 fixed on 14.
14th November.
হ্যাঁ?
Parliament
On 14th at 2 PM.
14th November.
14 at 2. Hardin part, most probably it was on the date. এই আগের দিনটা দেখুন তো।
I don't think last time, this was recorded as a part.
হ্যাঁ,
It was?
It was recorded most probably. এই অনেকগুলো ম্যাটার হয়ে যাচ্ছে তো একটা খুঁজে দেখুন। I shall check.
Copy আছে?
এই দেখুন তো আগের অর্ডারটা মনে হচ্ছে এটা। If it is not, it would be made. হ্যাঁ, ওকে। হ্যাঁ, আগের অর্ডারটা দেখুন আগের দিন মনে হচ্ছে করেছে। হ্যাঁ, আগের দিনটা দেখুন তো। হ্যাঁ, মিস্টার মিত্র মেড দিস। এবারে বেকার হয়ে গেলাম। হ্যাঁ, করা আছে। It has been made পাঠার।
ও তাহলে ঠিক আছে, ঠিক আছে, ঠিক আছে, ঠিক আছে, ঠিক আছে।
হ্যাঁ, 14 নভেম্বর at 2 PM.
60.
হ্যাঁ?
60. My man.
30?
60.
60 এই 60টা দিয়ে দিতে করে দিই তারপর। বলবে না এবার বাকিরা সব আসবে কিনা দেখুন। তাই না? সবাই।
Well, this is a very short question of law first, then the facts part comes.
Yes.
My lord may be aware that a partner cannot file a criminal case against another partner for misappropriation.
For misappropriation.
Yes, very interesting, because the articles are of the company. So one partner cannot file a case for misappropriation of the company's funds by making a complaint. Well, I'll show you a lot of judgment. Now, please comes to page 37. That's the FIR. And at page 38, the gist and the Well, 41 is the FIR. 41. I, Naveen Chaudhary, son of Nandolal Chaudhary, resident of so-and-so, being one of the executive partners and authorized representative of Messrs. Krishnakai Traders LLP, a limited liability partnership firm, would like to bring it into a kind consideration that Messrs. Eastern India Flour Mills, having its office situated at so-and-so, represented to its director Vishwanath Kedia, Rajesh Kumar Kedia and Shrita Saraf, agreed to store goods of our firm in their land lying and situated at Delhi Road, Konchina Mode, PS Singur, allotting 2,000 square feet area of land for storing those as rent-free accommodation. That it was also unanimously resolved in the board meeting to the effect that Messrs. Eastern India Flour, having its office so-and-so, represented to its director so-and-so, shall allow our firm to store goods of our business safely in the land lying and situated at Delhi Road, allotting us 2,000 square feet of lands for storing those as rent-free accommodation. That relying upon the such assurance and on good faith, we entrusted goods of our business in the land, as stated above with effect from September 23, and thus our goods were under their complete control and supervision, as the surrounding areas and properties also belong to them. That our goods were under their safe custody, and we never gave any authorization to them to deal with our goods, barring to store their safety in the. That I, being the active partner of so-and-so, used to visit the said godown till December 23, until I suffered so-and-so. As per our books, huge stock of alloy steels products so-and-so, 3 crores 47 lakhs was lying at the said godown since last transaction was done. That all these stocks were duly reflected in our books and shown in GST. That after accident, I underwent a treatment in Calcutta and obtained bedridden for almost 2.5 months. And when I was about to recover from the injuries caused due to accident, I started facing problems in hernia, and I had to be hospitalized for the same from so-and-so for getting operated. After months of arrest, I managed to resume my work from 30th of September 24. Then, on 10th of September 24, when I visited the said godown, along with my staff, namely so-and-so, I was utterly shocked and surprised that all our stocks of alloy so-and-so, class so-and-so, was missing. And when I inquired and asked them about the whereabouts of our stock, then they kept mum and replied they shifted to those goods to another place for internal issues of the company and promised to bring back those stocks within a month. That thereafter, when I visited Mala, this is what I say. Now, Mala, please take as such, next page as such.
Yes.
As such, I request your good self to take necessary legal action against Vishwanath Kedia so-and-so, having his offer as so-and-so. I was mentally shattered owing such loss, as I mean thanking you. So, Malad, this was in the form of a 156.3. Now, Malad, first comes to the order. Now, Malad, if your lordship, please seize. Now, Malad, please seize one thing. I'll just show to your lordship. Now, Malad, your lordship has seen that the articles were in respect of a LLP company. Krishnika LLL company, Malad, which starts in the FIR first.
Krishna Traders LLP company.
Yes, for which I am a partner.
Yes.
I am a partner.
Accused Vishwanath Kedia. They are the owner of East India.
They are directors of that, and he was a partner along with me in the Krishnika. Well, please see.
That means Vishwanath Kedia also partner of Konishko Traders.
Yes. Krishnika LLM. Well, please come, Malak. A limited, that limited so and so.
Yes, yes. How from your reading?
Well, the first paragraph.
And the complainant Nobin Chaudhary is the one of the executive partner and authorized representative of Krishnika. Krishnika.
Yes. Now, let's just show this judgment, then I'll go to the other parts.
A limited liability pharmaceutical.
See the judgment of this court referring Supreme Court. And I give it to your lordship on the left.
No, let me clear. Vishwanath Kedia, Rajesh Kedia, and Sunita Saurabh was not partner of Krishnika. They are different. They are
saying of Eastern India.
Huh?
Eastern India.
East India.
Yes.
They are the East India power.
Directors of that company.
Yes.
Now,
now
who is the owner of the godown?
East India.
East India. Now, who is Krishnika? This gentleman?
Nobin Chaudhary.
He is the partner of Krishnika. Now, please comes to the LLP dated 57, at page 57. Now, please see 57.
So Nobin cannot be stated to be the partner of Messar East India Power Limited. Power
In that one. I'm not interested in that. Please comes to page 57.
Page 50. Yes. Yes.
Now, who is the partners? 3. Vishwanath Kedia, the present petitioner before your lordship.
Reconstitution LLP, yeah, this the agreement of LLP made in. Yeah, actually. Nomita Kedia, Rajesh Kumar Kedia,
Next page.
Between Vishwanath Kedia, Nobin
Chaudhary.
Kavita Chaudhary.
Limited liable partnership. That is the meaning of, my lord, whatever little I know of LLP, meaning of LLP.
The parties are
That is the first part.
It is Keysop
Forgings.
Yeah.
Yes.
LLP.
Now, my lord, next is, my lord, your lordship is aware that nowadays, after the judgment of Lolita Kumari, it has become, my lord, imperative that a preliminary inquiry has to be lodged. A preliminary inquiry has to be lodged. Now, my lord, if your lordship sees the order of the magistrate, মানে it was a straight FIR না তারপর রিসিপ্টটা দেখ না ম্যাজিস্ট্রেটটা just see the order of the man just give a lordship মানে I'm not
that copy
judgment
in the original complaint
36
with
is
the formal FIR
of the keep it with record fixed 11/4/25 for report
yes
yes now my if a lordship sees the 41A notice given to us
okay you serve notice
no I will serve
yes serve notice
but one please comes to my letter only
letter yes
51
yes
my lord if your lordship sees page 47 page 47 for a minute my lord
yes seizure list
yes my lord in respect of this case what was received my lord your lordship seen it my lord seizure list
incoming registered such and such incoming Out copy such and such.
Let's see the seizure where? At the top, my lord, please see place of seizure.
At Messrs India.
East India Cloud Mill. This is where, my lord, they have given it.
Yes.
My lord, if that is done, then why aren't they giving me compliance of 41A or 75.3? 35.
35.3.
Yes. Only to that extent, my lord. I'm not on anything else. I've not come for question of the investigation at this stage. I will come ultimately, but now I don't want that because I can't. It's the investigation is going on. But the question is, my lord, if a lordship please comes to my letter in response to the 41A notice at page 48.
Yes.
But please comes to, my lord, to paragraph 50.
Paragraph
15.
Page 50.
No, 51, paragraph 15.
Oh. Yes.
Well, please read what I've said, Palat. That one Naveen Chaudhary has been in partnership business with my client under the name of so-and-so, having his office at so-and-so. That the partnership firm is having its factory at Delhi Road, so-and-so of my client, and the premises in the name of Messrs. East India Flower, which your lordship told me just now. Then, my lord, during the promotion of business, partners have invested in the said business as per the terms and conditions of partnership deed dated 2/5/22. It is further informed you that most of the business talks my client had with the partner over WhatsApp chatting so-and-so, that during business terms on so-and-so, Naveen Chaudhary over WhatsApp had asked my client to provide his godown interest to him on rent-free paper for GST purpose. He tested my client, this is just for taking GST transfer, and requested for making it rent-free for the time being, and assured that upon the godown, he will start paying rent with the execution of necessary documents. Even my client's accountant so-and-so was advised not to charge or record any rent until the goods are being stored. However, till date, no agreement and executed in regard neither any rent has been charged thereto. So, basically, what I'm trying to impress upon your lordship, I'm wasting your lordship time. Not otherwise, I've given the chats between the partners. You see the bulk. I'm not going into that. What I'm trying to understand, I will go comply with the direction under 35.3. That compliance report has to be given by the I. Only that much I want before your lordships. Because they are not complying with my, I've personally taken interest in this matter. They are giving notices. I have sent a reply. They don't ask me to comply with the same. Only that part, my lord. Nothing more, nothing less. Let it be heard, my lord, after the vacation.
No, whether you comply with the instruction contained in the notice. You have just sent a letter. You have just sent a letter.
So, my lordship sees, if I did not comply with it, how could the seizure be done at my premises?
Seizure may be done. It was 35.3.
Malad, and the receipt, Malad, of page 46. Malad, please see page 46. Page 46, Malad.
Yes, I'm coming.
Page 46, Malad, just for a minute. Oh, lordship saying 75.3?
35.3, yes.
Oh, sorry.
To appear before him or at such other places.
That is what I'm saying.
So, have you appeared?
Yes, but please see space 40.
Now you want so that they cannot arrest or any coercive safety.
Yes.
But
let's see 46 at the bottom.
But the thing of is 2 crores, the goods, value of which with 2 crores, more than 2 crores were
no, the money is not
allegedly entrusted with you.
No documentary evidence to that effect. I have given my registers to him to find out whether there was any entry that go down or not. Well, please see page 46 for a minute, Ballard. Page 46 for a minute.
Yes.
See at the bottom. At the bottom one. Received on 21/2/25 at Singur PS office. It's my signature there. I had gone there. Malad, what I gathered, Malad, out of court records, I'll tell you, there is a fight between them. So, Malad, the contact I had there, I said, why are you wasting money problem? Why don't we solve it amongst ourselves? So he first says, you deposit 90 lakhs, then I'll start talking to you. Then, Malad, the case is filed. This is the best. Malad, your lordship can not take, don't take notice of it, but this is Malad because it's a basic between partners. This is Osanti is going on. And more or less, the lady is involved in this. So, Malad, nowadays, as your lordship knows, ladies are made directors, housewives are made directors for the purpose of income tax. A lordship knows it better than me. So, Malad, this is what I want.
No, if any interim protection is given, actually they will not settle the matter. Rather, they will go on.
If no protection is given, then I can't go and sit with them and settle the matter. Only to that extent.
I am directing you serve and then come. Let them come.
That will be after vacation. My pujar mode, I will be taken. Small favor.
I think that would be.
No, it's okay. I don't want your lordship to say.
Course of accumulated stop of 3 crore 44 lakhs 74.
No, that is your lordship. Your lordship doesn't believe in that.
Blanket.
I am a party to it.
Blanket.
I have lost that also.
No, you are not. You are not a partner of East India. You are.
I am a director of East India. It's my go down where they have kept it. Deputy
accused person.
I am one of the accused person, Vishwanath Kedia.
Yes.
That is what I'm saying.
But Nobin Patnaik or Nobin Sachansad,
Chaudhary.
Nobin Chaudhary, he is the partner of Krishnonika and partner of Kishop.
Kishop, I am a partner also. I am a partner of Kishop. Mal, please seize that judgment of mine, man. Please. But I worked hard for that judgment, Mal.
Yes.
Comes to paragraph 4.
4, yes.
Justice Sadhan Gupta, as his lordship then was. Please seize that one.
Yes. I have already pointed out that it is admitted position that petitioner is also partner in respect of the property in question.
That's what I'm saying.
Here it is not. Property actually.
What is the property? The property is the articles of Krishnika traders.
Article of?
Krishnika traders kept in my godown. And I'm a partner of Krishna Fauji. What has been kept there? Supreme Court judgments are there, my lord. Lordship will see. I worked hard in this matter, my lord. For a change, I worked hard. Okay, my lord. Justice Sadhan Gupta had given this order. Well, I'm not wanting stay of investigation. Let the investigation continue.
Ashwin, this revisional application has been prepared seeking quashing of Yes. ডাকুন ওরা তো এলোই না ওরা ভেবেছে চলছে 28 ডাকুন
number 28.
হ্যাঁ ডাকুন 29 দেখে যান এগুলো তো আর ইয়ে করে যান
29.
My lord, I am for the petitioner, my lord, item number 29. I am led by Mr. Sandeep Kumar De, my lord, kindly keep us what possible is coming. Are going the good numbered other.
Today you have adopted regulation up to 3:30 on 33 minutes. How it can be?
Just my lord, 5 minutes part.
Okay, yeah, today it would not be possible. Okay, let's say দেখে যান 30 পাঠার ম্যাটার গুলো আসেনি নিন
32.
30 to 32.
32, I am for the respondent, Vidyasagar University.
Oh, that matter. Oh, that disciplinary proceedings. Eh? Oh, Mr. Sannal was, Mr. Sannal. Yes. Yes, দেখুন আর কি নিন
33.
33, my lord, I am for the respondent bank, my lord, in this matter.
Which for the petitioner?
Mr. Vishnu Bhattacharya was leading on behalf of the.
Oh. What happened? পাঠাতে তো শুনেছিলাম তো। What's the matter about Mr. Bhattacharya?
This is regarding, Lord, sale by the bank, auction. Thereafter, my lord, non-registration of the property in question.
Oh,
But the issue which falls for your lordship's gracious consideration is as to whether the bank can take this specious plea. And they have issued, they say that, you know, the sale certificate and everything is there. But, my lord, they have sold a property, or rather, my lord, to put it this way, the property which was, my lord, the subject matter of mortgage. My lord, my humble understanding is, my lord, that subject to correction by my learned friend, it could not have been mortgaged. Because it is apparently, there is a thika element there.
Oh, yes.
Now, that
My lord,
being
I
a-
have, in this matter, I am led by Mr. Saptanshu Basu, my lord. If, my lord, some accommodation may be given, I do not, even a passover, my lord, may do, because I think he's busy. In the morning also, I had a word with him.
The only difficulty is, my lord, these persons, my lord, they are pestering all of us, my lord.
Huge amount of money. How much money?
82 lakh.
82 lakh.
Sir, that is substantial amount of money for a normal individual. Not be to him,
And before became vacation, what can be
kindly
not
seize the,
matter?
kindly seize the papers.
My lord has already marked his part heart, my lord.
Part heart is one thing.
Pathar, okay, since I have heard in Pathar, it has been Pathar, but
Now please see what they have done. Kindly comes.
Yes, the Thika property, keeping it a mortgage, you have granted
Please
loan.
see annexure P1, page 30.
So, Mr. Bhattacharya, I am keeping, I am fixing the matter immediately after reopening. What can be done?
The matter is, it can be heard today.
Mr. He is
No,
speaking.
Mr. Basu is going to come, definitely.
I had a word with him.
Accommodation. He is paying for
I am
paying for accommodation on behalf of Mr. Basu.
This is not the first time that he has paid for an accommodation.
No.
We are really suffering.
Earlier, I prayed for accommodation since bank was contemplating to engage one senior. That was one of
therefore
the reasons.
accommodation was paid for.
But also on the last occasion, the petitioner did not appear. Kindly see.
Okay, now
Last
henceforth I
occasion,
shall note down. Although to avoid any confusion, I write hard the learned advocate for the respective party. You know why it is written. Particularly for the learned advocate to appear on behalf of the authority.
Now, if your lordship sees, my lord, page 30 and 31 is the title investigation report furnished by the bank.
It is
investigation
30. Report.
Title investigation report by the bank's advocate.
Yes.
With reference to your letter dated such and such, I have examined the document.
Page 31.
30.
Oh, 30, yes.
I've been told that Mr. Basu is on his legs in another court, my lord. A matter is going on there. In courtroom number 238. HON'BLE matters are going there.
In that event, if he is in difficulty, I don't stand in the way, Mr. Basu. May it be taken up anytime next week before our pujas. We are really suffering, really suffering. I wouldn't have pestered on any other matter. Right, wrong, whatever happens, let it happen, this side of the vacation. Any day convenient to your lordship.
This side of vacation.
I am also, I'm extremely sorry to disturb your lordship, but otherwise, let me proceed, let Mr. Basu join. I wouldn't have bargained, but I cannot explain the situation. These people, they don't know me. They go to some advocates and the advocates, every day, they go on pestering, impressing upon me that please do the matter. Even today, the gentleman.
It is a problem everywhere, with in our fraternity. There's a common problem in our fraternity.
Ponzi scheme case, it will continue.
Yes, my lord. My lord.
Only 26.
So many parties are there, so many
26,
are there.
26 minutes.
I leave it to your lordship.
What can we do?
If I may take a chance, disturb your
side of
lordship on
vacation.
the 25th, 2 p.m.
This side of vacation.
Or on the reopening day at 2 p.m. It's a Friday. 24th, 2 p.m.
24th, my lord, it is normally it is a melancholic day for our. First day is a melancholic day for our.
Hey, Tanmoy Babu. ওইখানটা আমি তাকিয়ে
Normally there will be a not to attend or something like that. So that will not help my friend.
2 p.m. দিই
friend.
হ্যাঁ আমি ওটা খেয়ালই করি আমি সব ডেট দিয়ে যাচ্ছি কিন্তু 2 নভেম্বর থেকে ঠিক আছে 27 নভেম্বর 29 because in the next week it would not be
I can place my side of the story.
and you take action against the secured asset. What is which is the secured asset? A Tika property. Now that this fact, according